All hear me okay? My name is James Haworth, but before we get started, there are just a couple of housekeeping issues that I'd like to go through with you. With me today, behind the scenes, is Esther, who will be providing technical support should we need any. And if you have any questions, please use the chat function to the right-hand side of your screen, or tweet us at Lawson-West Law using the hashtag webinar. Esther will be monitoring these as they come through for me to answer later in the webinar. So, okay, let's get started. To begin with, let me introduce myself. As I say, my name is James Haworth. I'm a solicitor and director in the Lawson-West Family Law Department, with overall responsibility for that department. I have over 30 years experience in this area of the law, family law generally. Now, this webinar is entitled, I just want to see my kids. That's something that I've heard many times over the years. In today's webinar, I will talk about some of the problems that are faced by parents who come to me for help, the feelings experienced by parents in these situations, what the law says about arrangements for the children, how to resolve differences between parents regarding the children, parental responsibility, and finally, enforcement. I hope you find the content useful and informative, but what I must stress before I begin is that what I talk about today should not be treated as legal advice and is for general information only. If you need any further information or help, please contact me for specific advice, and I would, of course, be happy to help. As I say, the title of today's webinar is I Just Want to See My Kids, but it has as much relevance for any parent with children who is having difficulty working out the arrangements for those children with their ex-partner. What I will talk about today also applies equally to parents who are married, then who are getting separated or divorced, to parents who've lived together and are now separated, and to those parents who have never even lived together. If they have children, the law relates to them in the same way. Where I need to give an example of where parents are separated, I will refer to a situation where the child or children tend to spend the majority of their time with their mother, because that is the most common scenario in this day and age, and I use it for convenience. But there are many situations in which the children live with fathers. I've acted for fathers who have their children living with them, and the roles are therefore reversed. However, as I say, the traditional situation still applies. The children living with their mother is still the most common situation. There are also situations where the care of the children is shared by both parents, although not necessarily for equal periods of time, and that is known as shared care. There are other situations in which parents are in same-sex relationships or marriages. Sometimes children do not live with either parent, and that can be for a variety of reasons. Often children live with their grandparents or other family members of one of the parties. So there are different types of arrangements for when the parents separate, and what I will talk about applies to them all. However, for the purposes of this discussion, as I say, I will refer to children living with their mother and the arrangements needed for enabling the children to see their father. The information applies just as equally to all those other scenarios that I've mentioned. I want to start, though, by dealing with how parents might be feeling. Now, as a lawyer, I'm trained and have experience in dealing with advising people on matters of the law. However, when I'm consulted on child-related issues, it's often as a result of relationship breakdown or of a falling out between the parents. So in a situation such as this, the parents are likely to be suffering from some or all of a number of emotions which will inevitably influence their thinking when it comes to child-related matters. Not all parents find problems arise from their emotional feelings, but the types of feelings that can be present are anger, fear, resentment, mistrust, and lack of control. And these are all human reactions which no one should be criticized for having. We're all humans after all, not robots. But they do influence the way people feel about their partner, ex-partner, and therefore that can impact on the relationship so far as arrangements for children are concerned. What can be very hard to do is to dissociate those emotions from the arrangements that need to be made concerning children. Some people can do this, but others, perhaps understandably, find this very difficult. It is important for parents, though, to bear in mind the effect of a family breakdown on children of all ages. On the whole, parents fall out with each other, not with their children. It's therefore important that children are able to maintain a healthy relationship with both parents after the separation. As far as possible, children should be protected from the adult dispute between their parents. This is, as you might expect, an extremely challenging situation in which children live with one parent and arrangements are made for them to see the other, spend time with them and maintain that relationship with the other parent. In the scenario that I will be talking about, living with mother and spending time with father. I've come across many situations over the years, and no two situations are exactly the same as you might expect. But there are often trends and similar patterns of behaviour that emerge time and again. Although many different problems can arise, the sorts of situations that I have been asked to advise on and help can include situations in which the mother denies the father is the biological father of the child at all. The mother refuses to allow the child any contact with the father at all. The mother refuses to allow the child any contact with the father unless that contact is supervised by a trusted third party. The mother refuses to allow the child to be taken out by the father, effectively limiting contact taking place within the child's home. That can make the father feel very uneasy, and natural contact would be difficult to achieve. The mother refuses to allow the child to stay overnight with the father. The mother refuses to allow the father to see the child unless the child is prevented from seeing the new father's parent, the father's new partner, I should say. Very difficult one, that. The mother refuses to allow the child to go away on holiday with the father, either in this country or abroad. The parents are unable to agree about arrangements for the father to see the child over Christmas, and in particular on Christmas Day. Same can apply to birthdays and Father's Day. And in fact, there are many other situations that arise. Sometimes it is the father who comes to me with the request for help, the I just want to see my kids situation. But on other occasions, I am consulted by mothers who have their own concerns. For example, the father does not collect or return the child on time, or in fact at all. The father does not look after the child properly whilst he or she is in their care. For example, he does not follow a particular diet that is necessary for health reasons. He allows the child to be exposed to smoking or to other types of improper or unreasonable behaviour. The father argues with and is abusive towards the mother in front of the child. The father denigrates the mother or badmouths her in the presence of the child in a way that appears to deliberately be designed to try and turn the child against the mother. Obviously, such behaviour can apply to either parent. And finally, the father can associate with undesirable third parties, making mother very worried about the effect that might have on the child. This isn't a complete list, there can be others, but that illustrates some of the concerns that mothers can have in situations such as this, where the parents are living apart. As I said at the beginning, a lack of trust is something that parents often have following a breakdown. So the fact that the mother is relying in this scenario for the father to do the right thing is something that sometimes mothers can be find difficult to trust. It's also often very difficult for one parent to see the situation from the perspective of the other. And the differences that have been experienced by the parents in dealing with the arrangements of their children are sometimes an extension of the issues that existed and caused problems during the relationship and led to its breakdown. For example, there can be a power imbalance between the parents. And by that, what I mean is where one parent has a personality that is domineering, controlling, or bullying. And that behaviour may have been at the heart of what contributed to the breakdown of the relationship in the first place. So what happens then is that the parties no longer live together, but they extend the controlling behaviour to the relationship of mother and father in relation to when the parents see the child and how the child is brought up. That's the whole point. The relationship of mother and father continues despite the relationship as cohabitees or spouses having come to an end. So, what does the law say? Arrangements for children should, in the first instance, be discussed and agreed by the parents. I have represented many parents who've been able to do this, and my help is not needed in those scenarios. I help with divorce and financial issues that arise if needed. However, where there are child-related problems, for me to be able to give correct advice, I need to know what might be ordered by a judge if the parties failed in their attempts to reach an agreement between themselves and one of them has to apply to the court. The law is contained in the Children Act of 1989, section 1 of which states, when a court determines any question with respect to A, the upbringing of a child, or B, the administration of a child's property, or the application of any income arising for it, the child's welfare shall be the court's paramount consideration. So, the child's welfare is described by the court as the court's paramount consideration. Those words, very important. Not only it's not the only consideration, but it is the main and most important one. So, for example, the court isn't primarily making its decision based on things like what the mother or father want, which parent caused the relationship to break down, which is a very subjective thing in any event, which parent left the relationship, or which parent has the more money. It is difficult, really, to disagree with the principle that the court has to put the child's welfare at the heart of any decision that it makes, or, to put it another way, do what is best for the child. However, what is sometimes very difficult to agree is what is in fact best for children. When I am consulted, it's because parents simply cannot agree what is best for them, perhaps not in all aspects of the care, but at least in some of them. So the starting point for me is that the law presumes, unless the contrary is shown, that it is in the child's best interest to grow up knowing both parents. If the child lives with, for the purpose of today's discussion, with the mother, it is therefore important to ensure that the child is able to spend time with the father. Otherwise, how will the child know its father? There are, of course, some very rare situations in which it is not in the best interest of the child to grow up knowing its father or seeing it. These are very exceptional situations, but there is evidence to show that a child's best interests are served by not seeing the father. Then the court can make an order in that to that effect. So, what happens if two parents cannot agree on all the arrangements for their children? If attempts through the parents' respective solicitors are not successful in reaching an agreement on all issues, either or both parents are likely to want to make an application to the court to ask a judge to make a decision. The judge is, after all, impartial and will decide what is in the child's best interests. However, this is not an easy option, as the court procedure can be lengthy, expensive, and one over which neither party can have any control over the outcome. But before I can submit an application to the court on behalf of a client, there is at least one other hurdle to get over. The rules of the court require that anyone who wants to apply to the court for an order about their children, they have to make a referral to mediation. So what I do in that situation is I send a referral to a mediator, a request on behalf of my client to ask the parents to attend a mediation information and assessment meeting, which we call a MIAM. Parents are offered attendance at a separate meeting with the mediator, not together in case there are problems, so that the mediator can simply see if it is right and appropriate for the mediator to try and help the parties to find a solution to their issues about the children without having to go to court. Mediation is quicker, often, less stressful, and less costly than applying to court. And it's also a method that involves both parties having a little bit more control about the outcome for their children. Now, this webinar is not intended to go into great detail about the mediation process, but I would be happy to answer any questions that you have which relate to it. Suffice to say, not all situations are suitable for mediation, and not all mediations that begin are successful in reaching an agreed outcome. So, when mediation does not enable the parties to reach an agreement, the rules allow an application to be made to the court. It's also important for me to highlight at this stage that there are exceptions to the requirement to attend a MIAM, but again, if you need information about that, please let me know later and I will be happy to help. Okay, so let us assume that all attempts to reach an agreement about the children have failed, and either the mother or the father feel that the court needs to become involved. What applications need to be made? Well, custody and access, isn't it? Well, no. The Children Act did away with those terms in 1991, so quite a long time ago. The Children Act today says that a parent may apply for what is known as a child arrangements order. And this is a very broad-ranging order that can deal with a number of issues, including with which parent the child will live and for what periods. For what periods of time they spend with the other parents, including such details as what days and what times the children spend with each parent. And it can say where the children should be collected from and delivered to and by whom. There are, in fact, many other details that can be provided for in a child arrangements order, the purpose being to make it clear to both parties and indeed to the children, where they're aware of what's going on, what will happen, when, and how. The court order can also stipulate certain things that parents can and cannot do when the children are in their care. The child arrangements order often refers to the care of the children, whereas the old terms of custody and access implied that one parent, the one with custody, had total control over the child and how they were brought up. The other merely had periods of time to spend with the children, but little say in their upbringing. A child arrangements order recognises that the role of each parent is equal in legal terms, even if the children spend more time with one parent than with the other. There is no such thing as the main parent or a secondary or inferior one. This helpfully leads me to the subject of parental responsibility. Parental responsibility is a legal term which was brought into effect by the Children Act in 1989. It's a concept of which we call PR for short, and all parents who are married to each other, either at the time the child was born or if they get married after the child was born, have PR for their children. If the parents are not married, the mother will have parental responsibility automatically, but the father will have it as well if he has got his name on the child's birth certificate as the father. So what is PR? Well, it's a bundle of duties and responsibilities. I prefer not to refer to rights and to look more at rights being those of the child to be brought up properly by its parents. And the parents have the responsibility for doing that. In normal circumstances, parents who live together exercise those responsibilities normally without giving them a second thought. And they relate in particular to decisions about a child's education, health, religious upbringing, and whether they should be allowed to live abroad. And these are all decisions that are made by all parties who have parental responsibility. Now, usually in a situation where the parents are separated, even before so, that is the parents of the child. Now, in the real world, sometimes parents make decisions unilaterally that ought to be discussed with the other parent. Now, it is possible for one parent to apply to the court to make an application for a judge to make a decision about aspects of parental responsibility, either if they wish to take a step that is not agreed by the other parent, or if the other parent wants to prevent a step being taken without their agreement. An example of this is, say, where the parents follow different religions, and one parent wants the child to be brought up primarily in the religious upbringing of that parent, and the other wants the other religion to be the primary one for the child. That is a very difficult one for people to resolve, and sometimes a court has to step in to make a decision. Sadly, although court orders can be made, often those court orders that are setting out the arrangements for the children that should be adhered to by both parents are not. Currently, though, all child arrangements orders have notices attached to them warning both parents that they will be in contempt of court if they don't follow what the court orders say, and the subject matter in the court orders can say what other enforcement provisions can be made if there is a breach. Human nature being what it is, not all parents adhere to orders, so sometimes it is necessary for an application to be made to the court to enforce terms that have been breached. It's not easy, but courts do have the power to do a number of things, such as referring parents to attend a separated parents information program or to mediation. They can vary the child arrangements order and possibly even consider changing the child's living arrangements so that if the parent with whom the child lives for most of its time is being uncooperative and failing to comply with the order, the court can order the child to live with the other parent. The court can make an enforcement order that's suspended or otherwise imposing unpaid work, similar to a community service order in the criminal courts. The court can make an order for compensation for financial loss. And finally, and very rarely, the court can make an order for a parent to be committed to prison or pay a fine. I've deliberately avoided discussing specific scenarios, but would welcome any queries that you have. I cannot go into specific detail, but if you'd wish to discuss anything that's any particular problem you've had, I would be happy to arrange to meet up with you to discuss it later. So do we have any questions? Nothing through Twitter. I haven't got anything on my sidebar there. So having set aside some time to do that, if anyone does think of anything that they want to ask at this stage, please feel free to do so. Here we go. What are my rights with regard to changing my child's name? Well, that is a question that relates to the issue of parental responsibility, because one of the facts, one of the effects of parental responsibility is that a child is not allowed to be known by any other surname unless it's agreed by both parties. So if, for instance, the mother wants to change the surname of a child, perhaps because she's remarried and has other children who are known by a different surname, if the father has parental responsibility, then she can't do that without his consent. Obviously, she can ask the father if he will agree. It's up to the father really whether he does. But if the father doesn't agree in that situation, the mother can make an application to the court. And if the court feels that it's in the child's best interests, again, it's that provision, the child's best interest, to change the surname, then the court can order it, even though the father doesn't agree it. But ultimately, the court must make that decision. Now, obviously, both parents can put forward their arguments as to why they think the child's name should be changed or shouldn't be changed. And the court must weigh up the pros and cons and decide ultimately what is in the best interest of the child. So hopefully that answers your question on that. Anything else? Anything else? No? Okay. Well, hopefully I've covered things that have been of interest, but and that you've found interesting, and I think that really covers it for today. Thank you very much for watching the live webinar. I hope you found it useful. This recording will be available to watch again, and you will receive an email confirming a link to it. If you would like further information of any of the points that I've raised, please do not hesitate to contact me or a member of my team, and my contact details will be available on the email that you receive. So thank you very much and good morning. Make sure you went into your screen.